All rise. Thank you, everyone. Please be seated. Court is going to call 23 CRI 162, State of Ohio versus Aaron Drushell. Matter is to be set before the court for a sentencing hearing. We are conducting that live in courtroom 1. Defendant is present, represented by Attorney James Mayer. State of Ohio is present, represented by Assistant Attorney General Denise Salerno. The matter is before the court today for a sentencing hearing. The defendant on January 8, 2024 did enter a plea of guilty to count 7 of the indictment, tampering with evidence, felony of the 3rd degree. Counsel, before we begin, just one item of housekeeping. It's my understanding the indictment lists the year of the defendant's birth as 1977. I believe it's 1988. Is that correct?
Yes, Your Honor.
Motion to amend the indictment?
Yes, thank you, Judge.
All right. The court is going to grant that motion and note that the defendant's birth year should be noted as 1988 in the indictment. Attorney Mayer, is there any reason the sentencing should not proceed today?
No, Judge, we are ready to proceed.
Have you received a copy of the pre-sentence investigation in this matter?
Judge, your staff did make that available to me at my request a little ahead of time last week so that we could review it and have an opportunity to include some of its findings in the sentencing memorandum. So yes, we have reviewed it. We have no exceptions to its contents. We think it's accurate.
Thank you, Mr. Mayer. Ms. Salerno, did you receive that as well?
Yes, Judge, thank you. The state's had an opportunity to receive it and review it as well. Thank you.
Thank you. Mr. Mayer, is there anything you'd like to say on behalf of your client?
There is, Judge. Thank you. My client is 35 years old. He presents before this court, as you know, with absolutely no prior criminal record. Unlike most cases, I suspect that come before you for sentencing, where you have a good working knowledge of the case. In this particular case, I suspect you're about the best position that a judge can be in with respect to the facts and circumstances, given the fact that we had a lengthy trial that played out over a number of days. And so I don't think there should be too much dispute about what was presented factually with evidence that he has pled guilty to on January the 8th. Specifically today, Judge, I'm asking you, Mr. Drushell's asking you, all of the people that support him in the community, friends and family, are asking that you consider suspending a prison sentence in this case and placing him on an appropriate period of community control with whatever terms and conditions the court deems appropriate as to the community control. I think that that is best supported by a couple of facts that I want to highlight from the PSI. Number one, as I indicated, my client has absolutely no prior criminal record of any kind at his age, which is not always what we see here at common police court. In addition to that, he has pled guilty to a felony of the 3rd degree, a nonviolent offense that does not, in name, carry a victim. I suppose it's an offense against the administration of justice, certainly serious and certainly a felony of the 3rd degree. But as such, it does not mandate prison. It also does not place a presumption in favor one way or the other. So it's clearly a circumstance where the court is in the best position to look at all of this and make a determination. And so we also think that it is of great importance when we have someone with no prior record to look at how they scored on the Ohio Risk Assessment Tool. In this particular case, as I'm sure you noted, Mr. Drushell was polite and cooperative during his time with Mr. Niedermeyer. It appears as though Mr. Niedermeyer did a very thorough review of the case, and in completing the PSI and the testing portion, Mr. Drushell came back at a 2. I don't think it's an exaggeration to say that that's the lowest score I've seen on one of my clients, or for that matter, any time I've just been in a courtroom for a felony sentencing. I guess a 1 or if a 0 is even a possible score would be the only way to fall within the lower range than a 2. We have little concern that that's exactly the range that we would end up in. That's supported by his lack of record. It's also supported by the fact he presents with no drug or alcohol issues. It's also supported by the fact that he's been a hardworking, productive member of society following his graduation from high school. He went, got his paramedic EMT training and put that to good use in what he describes and all of his supporters describe as what was his dream job. It appears he was good at that, it appears he was committed in helping the community, and it appears as though, as a result of this plea, that all of that is lost to him as well. So there has been consequence that will forever be felt by my client that goes beyond just the conviction itself. And I would think that the conviction and at least the current loss of his job as a firefighter with no pathway going forward to think he'll ever get back into that field would also be something that is noteworthy as it relates to impact as far as the conviction in this case. It's not nothing, it's significant to him. In addition, Judge, we attached upwards of 30, 35 character references on behalf of my client. These are family members, friends, people he's worked with, people from the community, people that are not obligated to say nice things about him. Certainly family members, you would hope, but that's not always the case. But these are people that have had real life experiences with him. They speak to someone with a gentle, kind character, someone who helps people that in need without ever expecting anything in return. Clearly, that's not the picture that was painted during this trial with respect to the facts and circumstances in this case. But I do think it's really important to note that despite the evidence that was presented at trial as it relates to the type of person my client is, it's not the opinion that is shared by certainly a large number of people in this community that have gotten to know him at all sorts of different points in his life. And just the nature of what they have to say about his willingness to volunteer, run fundraisers for people that are in need, giving back in any number of different ways to the community, is consistent with the type of person that I've gotten to know during the couple of years that this has been pending. The other thing that I think is really important, it's oftentimes said that the best indicator of whether someone will make a good candidate on community control is how they perform during pretrial supervision and during the time that they're on bond. Not everyone has the benefit of being out during the pendency of the case, but when they are, they're going to create a track record. And certainly this court is well aware that this case got started with an arraignment back on March 14th of 2022, coming up on 2 years ago now. And at that time, my client pled not guilty, posted a bond, and he was outfitted with a GPS tracking system. My client strictly abided by each and every term and condition of his bond without fault. And I think that that means something when it comes to trying to predict, is this someone who's amenable to a period of community control? Is he going to respect the authority of the probation department? Is he going to take this seriously? Or is it simply going to be a short stay on community control with an expectation that there would be a prison sentence on a violation? Certainly when people get out on bond and use drugs or violate or cut off their bracelet or stop showing up, it becomes an easy decision as to whether or not they should get a chance on probation. And I think that when people are on the other end of the spectrum and do very well, that should count when it comes time to decide whether they're a good candidate for community control. The next thing I'll mention is that despite the fact that he lost the job with the fire department, which was very upsetting to him, disappointing and devastating in many ways, he didn't choose to just sit down and wallow in self-pity in his house and wait for this case to play out. My client worked 2 jobs during the time that he has been pending trial, neither of which were in his preferred training field. Instead, they're hard-working concrete jobs and also HVAC jobs, which did require quite a bit of trust from the probation department in authorizing and the court and allowing him to travel to different parts of the state, be compliant with what he was doing while on bond and those other places. And all of these things went off without a hitch. And it demonstrates that he's someone that, if given a chance on community control, will do the very best he can to continue being productive and work even if it's not in the field that he wishes he could continue in. Judge, with respect to who he is sitting here today, this case essentially was very, very, very difficult case for everyone involved, and we recognize that. Certainly, we've had an opportunity to read statements that have been presented on both sides of this case, shared those with my client, and there's just no doubt that the feelings are very strong on both sides. It's a tough case. It's a case that tried out over several days, and we had 12 hardworking jurors that spent the better part of a day and a half to 2 days trying to do their best to reach a verdict and just weren't able to get there. And in the end, it just suggests that what we had here is a case where certainly there was doubt. And I've got a client that was in the fight of his life, essentially, and ultimately was given an opportunity to resolve this matter. He's thankful to be able to accept responsibility. He wishes he had not deleted text messages. He understands in hindsight there were things he certainly could have done differently to have avoided that charge in the first place. But I do think it's worth noting as it relates to this tampering with evidence. We heard testimony from Detective Major. The court's had an opportunity to read reports, even some information as part of the PSI that maybe wasn't part of the trial. And what's clear is there was the passage of time here, many weeks, before ultimately the police did make contact with my client. He was not running, he wasn't hiding, he was simply going to work. He was easy to find, but for investigative reasons, they elected not to get in touch with him right away. When they did, he was nothing short of just cooperative. He was under no obligation to sit down with the police, with an attorney, by the way. Any attorney is going to advise him that's probably not in your best interest to make a statement with a detective, but he said, no, I want to tell my side of the story. He sat down with Detective Major, who by anyone's account is one of the best detectives when it comes to extracting confessions and getting to the truth of things that perhaps this county or anyone in a 2 or 3 county radius has ever seen, which is an excellent reputation for getting to the bottom and getting folks to talk about things that they didn't plan to talk about when they first sat down with her. He sat there for an hour plus, maybe even approaching 2 hours, and never once deviated from where he was on it. And even still after the interview, he went down, didn't have to, with Sergeant Dorsey, sat down, went through his phone, went through his emails, and did the best he could to try and help them recover information that he thought could help. We all wish that the couch video was something that had been properly preserved, but I don't think that the trial got us any closer to understanding just exactly what it is or how it is that the couch video was not made available for this trial. Certainly there were other things with respect to the deleting of messages that in hindsight he absolutely should not have done once it was clear that perhaps the investigation hadn't gotten going, but he was definitely on notice that one was likely to be instituted once these messages started coming through. And so he owns the fact that there was certainly some deleting of some items that he had no business deleting in the condition that he was in. In the end, he's going to speak to you here briefly, Judge, and he's going to focus on his plan going forward. He's going to focus on what his message is today, and what he's hoping is that you consider him for a period of community control. I don't think that there's anything based on what he has pled to, not what he was on trial for, but what he has pled to that would suggest anything other than a community control sentence. Mr. Drushell is mindful that oftentimes in Ashland County, a community control sentence can start with a period of local incarceration. He hopes that you would consider just a straight period of community control with a suspended sentence. He points to the amount of time that he was on the ankle bracelet, and while not incarceration, certainly it is a restriction on his freedom, and he never blinked. He went through that without any issue, and he hopes that you take some of that time into consideration as to whether an incarceration sanction is necessary or not. He is working. He's concerned he could lose that job if there was a period of incarceration. We certainly would have no issue as an alternative, as something more than just community control straight away is not in the cards today. We would hope maybe you would consider continuing him on the ankle bracelet so that he could go to work, or perhaps make use of the CAC as an option at his expense over in Mansfield, or perhaps he could come and go and keep that job while he spends some time in a residential sanction. In the end, Judge, that's what we have. But thank you for your time presiding over the matter during the trial, and the opportunities to have more conversations here before sentencing today, including before getting started. That's what we have. We're asking for probation. Thank you.
Thank you, Mr. Mayor. Mr. Drushell, is there anything you would like to say?
Judge Stemper, I stand before you today with a sincere desire to leave the past behind me and move forward in a positive direction. The last 2.5 years have been the challenge of my life, but I am determined to turn things around and become a productive member of society once again. I am asking for your leniency so that I might have an opportunity to prove myself. I can assure you that if you grant me probation, you will not have any further issues from me. I do not have any drug or alcohol dependencies, as evident as my clear drug and alcohol testing results. I have fully cooperated with all requests from the courts and surrounded myself with supportive and productive individuals who have stood by me throughout this ordeal. The consequences of my actions have taken a significant toll on my life, including the loss of a career as a firefighter and paramedic, as well as financial hardships. Despite these challenges, I remain determined to rebuild my life and secure my financial future by attending a trade school. I have maintained employment throughout this process and will continue to do so during probation. I humbly ask for the opportunity to prove myself that I am capable of success and redemption. Please consider granting me the chance to move forward and make a positive impact in society once again. Thank you for your time and consideration.
Judge, may I, real quick? So, let's see. One thing I did want to point out in the PSI that I forgot to mention, it does indicate that he has recently been diagnosed with situational depression, anxiety, but it mentions that he's not currently seeing a counselor. I'm not sure if that was an oversight by Mr. Niedermeyer, but as evidenced by Defendant's Exhibit 2, we do want to make sure the court is aware that on his own, Mr. Drushell has engaged Dr. John Jordan, who I think authored a really nice treatment letter, which does an excellent job kind of pinpointing what I think the issues are that Mr. Drushell presents with, convicted or not. And I think it's encouraging to see that he's trying to work through all of these things, even though the court had not made that an order of his pretrial supervision. And so we want to make sure that the court is aware. I'm sure you go to Defendant's Exhibit 2, but the PSI did not reference the counseling. He absolutely has been doing that, just as indicated by Dr. Jordan, and he intends to continue with that no matter what the sentence is today. Thank you.
Thank you. Attorney Salerno, on behalf of the state.
Thank you, Judge. Earlier, I provided the court with a statement from the victim. I do want to note for the record that I've been in a lot of contact with the underlying victim in this case. She's not present today. We've talked about her statement and why she's not here. She is aware that the sentencing is going on, and I believe that she's made her feelings pretty clear in the statement provided. And I know that the court has reviewed that, the defense has reviewed that, and that's one of the things, along with the items provided by the defense and the PSI, that this court obviously takes into consideration in coming to its determination. So I thank you for that. And I think that statement speaks for itself. Although I have a duty to stand here and speak on behalf of the people, because that's who I represent, is the people. And I'm glad that the defendant has a great support system. It's important. It's important that he has good opinions from his family and friends, but those people weren't there during this situation, any of it. We're assuming nobody was part of the defendant's decisions that bring us to this tampering with evidence charge today. So that's what we have to deal with, is the defendant's choice, his actions, not anybody else's actions or anything else that the defendant has done regarding his family and friends. You heard the testimony. We spent a lot of time talking about the videos in this case that the defendant had in his house, and it's important that we keep that in mind, that the only evidence we were able to present were 2 moments within a video that the defendant had at his house that occurred at the very end of this entire interaction. We don't know anything else that happened before that. All we know is that the defendant said one thing happened, the underlying victim said something else, but we don't know. It's gone. It was chosen not to be saved when those other 2 moments were saved. Now, that is serious, because the defendant isn't just a normal person walking around in the street. He's a fireman, or he was at the time. There's a reason why historically, when you ask little kids, what do you want to be when you grow up? They don't say lawyers. They say firemen. They say policemen. And that's because our society holds those people in such high esteem. They're idolized on TV. They're idolized in movies. They're held in very high esteem by our entire society. When a fireman or police officer walks out of their district, walks off the job at night or during the day, whenever, they're still a fireman. That carries with them in every aspect of their life. That's why they take an oath. That oath is to protect and to serve, not themselves, but everybody else, to the point that they're willing to sacrifice their lives. And that's very serious. And that makes this charge very serious too, because what we have here is a fireman who made an oath to protect and serve the community, that when, as he's stated, something bad happened, he panicked and deleted things. He panicked and he made a decision to do something that isn't just wrong, it's illegal. And that's serious. For our society, if we can't trust firemen, if we can't trust policemen, who can we trust? Now, I've said more than once to both the court and the defense, the state is ultimately deferring to your judgment in this case on sentencing. The community obviously trusts you. That's why you're here. We trust you. I've spoken with the victim several times. We trust your judgment in this case. We know that you understand, obviously, everything. You've heard the testimony. You were sitting there. But I think on behalf of the people, it is important to remember that the defendant isn't just some regular, normal person coming off the street. He's in a very unique and special position, as are all policemen and all firemen, and anybody else in this courtroom is one of them. We take oaths too. We're held in a certain position too. And that needs to be taken seriously. And if this court does put the defendant on probation, the state asks the court to provide a meaningful probation, a meaningful length of time that doesn't just reflect the seriousness of this crime, but the seriousness of this crime as it pertains to people in the position that the defendant was in, that trusted position. Again, I do appreciate your time. We appreciate all your attention. We appreciate you taking the time to listen to the victim's statement. We know it was very important to her and appreciate that you've done that. We do also understand we're only here on tampering, and that's it. That's where the plea is. So the conviction is strictly going to be for that tampering charge. The state's also going to ask, in the event that this court decides to place the defendant on probation, the victim has asked that we ask you to place a post-conviction no contact order on the defendant as it relates to the victim, just for her peace of mind and for her security, if the defendant is placed on probation and allowed out of the community in lieu of any kind of a prison sentence. Thank you, Judge.
With respect to that last request, Judge, we have no objection if he's placed on community control to a rule or a condition of his community control be the ongoing no contact with the alleged victim in this matter. I'm not sure, though, as to the propriety of a full-scale post-conviction no contact order with respect to this alleged victim, when in fact all of the charges that pertain to her were dismissed. And for that reason also, while we understand that the statement was provided to the court, I've had a chance to review that with my client from the alleged victim in this case. We also object to its application to any sentencing for the same reasons that she ultimately, the charges pertaining to her were dismissed on the motion of the state of Ohio following the hung jury. Thank you.
Take a minute. court has received and reviewed that pre-sentence investigation from Mr. Niedermeyer. It does indicate the Ohio Risk Assessment score at 2, which is low. I have reviewed the case history in this matter and considered the statements today of counsel and the defendant. I've also received and reviewed a victim impact statement. I am finding for purposes of Marcy's law that the alleged victim did have the opportunity for input, has been provided notice of this hearing. The court also received and reviewed a sentencing memorandum on behalf of the defendant, which does set forth numerous letters of support. The court has considered the purposes and principles of felony sentencing, including 2911 and 2912, as well as the relevant serious and recidivism factors and the guidance with respect to this level of offense. I think it's appropriate to give a little bit of background in this information, or in this case. The allegations that gave rise to the present matter were originally charged in this court under a different case number, 22 CRI 078. That was by indictment on March 11, 2022. The defendant was originally charged in that matter with a single count of rape, 1 count of sexual battery, and 1 count of tampering with evidence. Prior to trial, the Attorney General's office, acting as the special prosecutor in this matter, charged the defendant with the indictment in the present case, which separated that single count of rape into 5 counts of rape, each for a different sexual act, added 1 count of kidnapping, added 1 count of gross sexual imposition, and kept the previous count of tampering with evidence. Those were the charges that were presented to an Ashland County jury in this matter starting on July 5th, 2023. That trial did proceed for 8 days. I presided over that trial. As you alluded to, Mr. Mayor, in doing so, I did hear the facts of this case, really, I think, in great detail. Nonetheless, I did go back and review portions of the testimony provided during that trial, as well as my notes about the entirety. I have reviewed that pre-sentence investigation, including the police reports that were contained within it. It does appear to me that the state of Ohio was able to present that case to the jury and to give the jury the evidence that they had. The jury deliberated for the better part of 2 days and could not reach a conclusion on any of the counts. By happenstance, the court is aware of some of that deliberation, and I won't go into detail about it, but I will say this was not a case where 1 or 2 jurors were holding out for one side or the other. This was a case where 12 members of the jury could not decide. There are certainly 2 sides to what happened that evening, which really focused in on the issue of consent. The alleged victim has remained steadfast in her side of things. The defendant has maintained his innocence as to the sexual charges throughout the proceedings. After hearing those sides and the evidence, the jury could not reach an agreement. Having sat through that trial, I understand the jury's difficulty in deciding this case. I am not confident that a different jury would have had any easier of a time reaching a conclusion. I also don't know that either side would have presented their case in much difference than the way it was presented the first time. So it is certainly possible and potentially likely that we could have ended up with another hung jury. Nonetheless, I was prepared to retry the case. I know that the prosecutor and defense have been in communications regarding the matter in the meantime, and you kept the court apprised of those communications. The prosecutor, after conferring with the alleged victim, ultimately decided not to retry this matter and extended the offer that was accepted by the defendant, and which is what brings us here today. While I understand it certainly might not be ideal in the eyes of the alleged victim, my understanding is she did not wish to go through another trial and was at least comfortable with this resolution. Also, I would note that neither she nor the state of Ohio is asking the court to impose prison. I do not quarrel with the decision of the state. I understand the parties not wanting to go through another trial. This had to cause extreme embarrassment, stress, and grief to everyone involved. I think everyone who left the courtroom after that trial realized that this was an incredibly sad situation all the way around. But the question today is, where does that leave us? It leaves us with a defendant admitting to one count of tampering with evidence and maintaining his innocence as to the rest. In this country, you are presumed to be innocent until and unless you are proven guilty beyond a reasonable doubt. In this court, that still means something. The Constitution and due process means something. And what that means in this case is the defendant was not proven guilty of any sexual offense. So I will not be sentencing him today for rape or any other charge besides one count of tampering with evidence. That's what he's been found guilty of. That's what I will be sentencing for. I'm also required to follow the laws under the state of Ohio as they pertain to sentencing. Those laws say that a court must follow the overriding purposes of felony sentencing, which are 1, to protect the public from future crime by the offender and others, 2, to punish the offender, and 3, to promote the effective rehabilitation of the offender using the minimum sanctions that a court determines accomplish those purposes without imposing any unnecessary burden on state or local government resources. To achieve those purposes, the court shall consider the need for incapacitating the offender, deterring the offender and others from future crime, rehabilitating the offender, and making any restitution. A felony sentence shall be reasonably calculated to achieve those 3 overriding principles and shall be commensurate with and not demeaning to the seriousness of the offender's conduct and its impact upon the victim, and it shall be consistent with sentences imposed for similar crimes committed by similar offenders. The court is required to look at several statutory factors indicating that recidivism or reoffending is less likely, and no factors indicating that it is more likely. As alluded to by Mr. Mayor, the defendant also has one of the lowest Ohio risk assessment scores that this court has ever seen. With respect to the evidence presented to this court regarding the tampering with evidence charge, in my opinion, it involves several aspects that I'm going to address. I think you clearly deleted 2 photographs and 2 text messages that you sent from a text message chain. Your explanation to law enforcement at the time was that they were embarrassing. I would note the photos involved pictures of yourself. The text messages were also explicit, but you left the remaining portions of that conversation. We know that because the state had the other side of the conversation from the alleged victim. So the state had those. The jury saw those. They were still available, regardless of your intentions or your actions. Then there is the question of the video. Essentially, the evidence presented showed that you saved some portions of the Nest camera video by recording them on your phone. There was evidence presented that Nest automatically tapes over or erases when it's in continuous recording after a period of 5 days. What was alleged, what was alleged to be missing was certain actions prior to sexual intercourse that occurred on your living room couch. So specifically, what happened on the couch prior to going to the bedroom. And to me, that really was the critical question when looking at this charge and the others. When I went back through the testimony and my notes, the evidence was that you attempted to email that video to yourself. There was some kind of glitch, according to you. But law enforcement did verify that there was, in fact, a link for that video in your outbox. Now, the link didn't work. And to this day, I don't really have an explanation for why. But there was no direct evidence presented that you deleted that video. In fact, going through my notes, the argument to the jury by the state was not that you deleted the video, but that you only preserved certain portions of the video that you wanted. that you allegedly manipulated the video by going to the sections that you wanted and recording those. The law requires you to alter, destroy, conceal, or remove. Mr. Drushell, if I was convinced that there was video of you committing a sexual assault on somebody and you deleted it, you'd be walking out of this door and going to prison for a long time. But I can't say that the evidence presented supports that. There was no direct evidence of that. There was, even by insinuation, no real evidence of that. And like I said, a jury of 12 people can decide the case. So I'm not going to substitute my judgment for them. However, from the evidence that I did hear and what you admitted in the pre-sentence investigation and here today, you did at a minimum delete text messages and photos knowing that there was an investigation in progress or about to be. So the question today is, what do I do about that? Your attorney is correct. This is not a sex crime. This is not an offense of violence. It's not an offense against a child or family member. I understand there are people that look at you and what you did in your career and think you're getting a break that other people would not. Personally, I think the fact that you were a firefighter cuts both ways, as Attorney Salerno points out. If nothing else, you should have had a greater sense of the value of evidence. But regardless, I'm going to approach this case like I would any other case, because that is what I am required to do. And in any case that comes before me, I first look at the facts presented, and I've gone through those. And I will be sentencing you for those facts relating to the crime for which you've admitted. Not what other people may want to be true or think are true, but the facts presented in this court. I do also consider the position of the alleged victim in this case. I understand that the sexual charges have been dismissed, but I think under Marcy's law, she's still entitled to input, and she has had that ability to have input. She's not advocating for a prison sentence. The state of Ohio is not advocating for a prison sentence. I look at your record, Mr. Drushell, and you're right. You have 2 seatbelt tickets in your entire life. You've lived a law-abiding life for a long period of time, which is absolutely something the court is required to consider in fashioning a sentence. The court would also note that I read the letters in support of you in the life that you have lived. And then I look at your performance on bond. Your attorney's right. You've been constantly monitored since you turned yourself in. You've had 0 bond violations for the last 2 years. And then lastly, I look at previous sentences that I've given to people with similar offenses. The sentence I'm going to give you is consistent with those, although admittedly most people do have somewhat of a record come before me. You do not. Nonetheless, on standalone charges of this nature, those people have received community control sanctions. So because of the factors the court has listed, the court is finding that community control is consistent with the purposes and principles of felony sentencing, which means I'm going to suspend the prison term associated with this level of offense of up to 36 months in an appropriate penal institution. However, this is still a felony offense. As such, I do feel like the seriousness involved does merit a period of incarceration. The court's going to order that you serve 90 days of incarceration. I am going to grant your request to permit that to be done at the Community Alternative Center in Richland County. That's a lockdown facility, but it does allow you to leave for work, which currently, in my understanding, is our jail does not. You will have to pay for that. The court will give you time to complete that. If you have not completed it by the report date, you will need to turn yourself into the Ashland County Jail. You will also be supervised by this court for a period of 3 years. The maximum is 5. I considered imposing the maximum, but I want to give you credit for essentially being on community control for 2 years. I will explain the terms of your supervision in a minute, but my probation department will be watching you very closely. It is important that you comply with the terms and conditions of your probation to a T. You have 1 day of jail time credit as of today. It will be the order of the court for a period of 3 years. You'll be subject to supervision by the Adult Probation Department here in the courthouse. Before you leave today, you'll need to sit down with them. It's at the other end of the hallway from where we're at. They will start you at what's known as a high or res level, which is a minimum of 1 face-to-face contact per month with your supervising officer. That will continue until your supervising officer finds it appropriate for you to step down. Your terms are that you follow the law, federal, state, local, not leave state without permission of your supervising officer, comply with all the rules and regulations and conditions of probation that they're going to go through with you, and any further orders of this court. I have no reason to believe this is a problem for you, but you're going to be under an order not to use any illegal drugs. That does include THC, which is still federally illegal. You will be subject to a supervision fee, which is $50 per month, effective with the journalization of my judgment entry. Court is going to order no contact with the alleged victim in this case as part of your probation. That means no contact whatsoever. That means you don't go within 500 feet of that person. You do not enter or interfere with the residence, school, business, place of employment, daycare centers, or child care providers of that person. You cannot violate that even with the permission of the protected person. Shall not harm, attempt to harm, threaten, follow, stalk, harass, force relations, sexual relations on, or commit any sexually oriented offenses against that person. And you shall not initiate or have any contact. That means any direct or indirect contact, text messages, emails, voicemail, nothing. No contact. Do you have any questions about that portion of the order?
No, Your Honor.
That will stay in effect through the 3 years while you're on supervision. Additionally, you shall continue with your mental health treatment and counseling. You'll need to sign some releases so that the probation department can follow up and make sure you're doing that. You are to follow up with any recommended treatment or aftercare. Do you understand the terms I've gone over with you?
Yes, Your Honor.
Now, if you violate the terms of the community control, you violate the law, or you leave the state without permission, I'll have several options available. I could keep you on probation and extend it to the maximum of 5 years. I could add additional or more restrictive sanctions, again, including jail time or incarceration or other residential sanctions. Or I could terminate your community control, and I can impose a prison term from the range from your level of offense. That can be consecutive to any new time you may receive if you commit a new felony while on community control. With respect to this level of offense, that is 9 to 36 months that is being reserved in increments of 9, 12, 18, 24, 30, or 36. With respect to financial sanctions, I am finding you do have the ability to pay financial sanctions. So I am assessing court costs in this matter. I am also assessing a fine of $250. I am keeping the fine low because, quite frankly, the court costs in this matter are going to be very significant, and you are responsible for the court costs in this matter. If you fail to pay those court costs, the court can order you to perform community work service, which would be credited against those court costs at the minimum wage level. Mr. Drushell, you do have the ability to appeal my decision. Any notice of appeal does need to be filed within 30 days of my sentencing entry. If you're unable to pay for the cost of the transcript or the record, that can be provided to you without cost. Likewise, an attorney can be provided to represent you in the appeal, including to file a notice of appeal if you are indigent upon your request. The court is going to order the pre-sentence investigation and the victim impact statement be filed under seal in this matter. I am going to assign a report date of June 15th, 2024 at 8 a.m. So that gives you time to go do that sentence at the Community Alternative Center. The probation will be able to assist you in getting the contact for them. If you have not done so, you need to report to jail at that time. I am going to leave you on bond until you either complete the Community Alternative Center or you turn yourself into jail. So you will continue to be monitored through the GPS monitor and all other conditions of your bond. Do you have any questions about your sentence, sir? Attorney Salerno, anything further?
No, thank you, Judge.
Nothing else, Judge, thank you. I think that covers everything.
All right, that will conclude the sentencing. Mr. Drushell, you'll need to report to probation, as I said, before you leave.
I'll make sure it gets counted, Your Honor.
We go. All rise.